Welcome to the Edmonton Community Legal Centre's presentation on property division. The information presented during this session may have limited application to your particular situation. I can provide legal information that may give you a greater understanding of how the law might apply to your own situation, but I cannot provide you with individualized legal advice. In this presentation, we are going to talk about property division for married people, property division for people who are not married, who lives in the house while the property is being divided, and how is property divided if there is an agreement already. First, let's talk about property division for married people. We're going to talk about what law applies to property division, what are the time limits, how does property get divided, who lives in the home while property division is being sorted out, and how you can protect property. The law that applies to property division is the Matrimonial Property Act. The Matrimonial Property Act does not apply to people who are not married. This only applies to matrimonial property. Who can use the Matrimonial Property Act? Here is a chart that is also located on page 6 of the handbook that accompanies this presentation that sets out if you can use the Matrimonial Property Act. There are time limits that apply to making applications under the Matrimonial Property Act. If you are separated but not divorced, you must apply 2 years from the date of separation or start divorce proceedings. If you are divorced, you have 2 years from the date of the divorce judgment to make an application. If you are giving away or selling property to defeat a Matrimonial Property Act claim, then an application needs to be made 1 year from the date the property was sold or given away. If one of the partners has passed away, an application needs to be made within 6 months from the grant of probate, but only if you have started an action before your spouse died. Generally, applications to divide matrimonial property are made in conjunction with a divorce application. So let's talk about how matrimonial property is divided. First, we need to look at whether or not there's a pre-existing agreement between the parties. There's various types of agreements that could be made. Agreements that are made before moving in together. This could apply whether you're married or unmarried. We often call these prenuptial agreements. Agreements can also be made while parties are living together. If circumstances change and someone wants to determine how property will be divided, just because they're already married doesn't mean they can't now come up with an agreement that will govern how property will be divided in the future. And finally, agreements can be made at the end of a relationship. Examples of each of these kinds of agreements can be found on page 23 of your handbook. There are a number of methods for reaching an agreement that exist on a spectrum from how much control you have to how much assistance you need from other people. You can make your own agreement, which can save you time and money. You have control over what the agreement says. There are certain legal requirements, including talking to a lawyer to make sure you understand the agreement. You can mediate. Mediation is when you meet with a neutral third party who will help facilitate a conversation to help you reach an agreement. Mediation should be done early if you can. Mediation is often very successful, so it's often worth a try. You can hire a private mediator to do this for you. You can also try collaborative law. In this case, each person has a lawyer and signs a contract that they will not go to court and that they will work together with the other person. Most decisions are made in a 4-way meeting, and information is openly shared. There are specialized lawyers for collaborative law. This is different from mediation in that there isn't a neutral person involved facilitating the conversation, but each person has their own lawyer. People are still focused, though, on reaching a resolution. One option, if you need to get a lawyer involved, is what's called a limited scope retainer. In this case, a lawyer provides some legal services for part of the legal problem, but not for all the legal services. If no agreement is possible, then a matter might proceed to court. You can hire a lawyer or you can self-represent. If you don't have an agreement or are unable to make one, there's a number of steps to go through to divide the property according to the Matrimonial Property Act. Step number 1 is to make a list of the property. Make a list of all the property that you own. This includes property outside of Alberta. Property includes things like cars, bank accounts, pensions, real property, investments, etc. You should include property that you purchased after you separated. You should write down when you purchased the property and how much it was paid for. This should also include a list of your debts and other liabilities. Step number 2 is to value the property on your list. When deciding how much something is worth, there's a number of ways to value it. If the matter is going to trial, it'll be valued as of the date of trial. You can also choose, if you're trying to make an agreement, a date with your partner. For for example, the date of separation. Some property is taxed when it's used, for example, RRSPs, so you need to make considerations for tax consequences for certain types of property. You can make a separate list for that kind of property. Step 3 is to share your information with your partner. Sharing financial information is often called disclosure. You must provide honest disclosure to the other person, and they must provide you with their information too. You can use a notice to disclose to get financial information from the other side. This is an application made through the courts. The rules of court have other methods you can use, such as questioning. Step 4 is to sort the property into the headings provided under the Matrimonial Property Act. There are different kinds of property under the Matrimonial Property Act. Property that will be divided equally between the spouses, property that will not be divided between the spouses at all, property that will be divided between the spouses but will be divided based on what is fair given the circumstances. Starting at the bottom of this chart, we see property that is exempt from sharing. This is inheritances, property that one spouse owned before the marriage, gifts from third parties just to one of the spouses, or any award or settlement of tort damages or proceeds from a non-property insurance policy. For example, if someone has a personal injury or a car accident. This is called exempt property and is not divided at all between the spouses when they divide their property. Moving up, we see property that is shared, but not equally. That's generally divided based on what's fair. This includes increases in the value of exempt property. So for example, if someone had an inheritance and it grew in value, that increase in value might be divided, but the inheritance itself is exempt. Income received from exempt property. So for example, if someone has a house from before the relationship, but then received rental income during the relationship, that income might be divided, but the house itself is exempt. Property acquired after the separation, and gifts from one spouse to another. Generally, the rest of property is shared equally between the parties. The matrimonial home, vehicles, pensions, and investments are all included in that. For further examples of exempt property, please reference page 10 of your handbook. To make a claim for exempt property, you must still have the exempt property or be able to trace the value of the exempt property into a current asset. For example, if Kim owned $40,000 in RRSPs before the marriage, and she still owns those RRSPs, then that value won't be divided because it's exempt. However, if the asset can't be traced, then the exemption is lost. For example, Ryan received a $10,000 inheritance. He and his wife went on a vacation and used the leftover money to pay bills. Ryan can't trace the money into an existing asset, so he loses his exemption. You may also lose a part of your exemption if you put exempt property into a joint asset. Some property, as we discussed, will be divided based on what's fair in the circumstances. The judge will decide what is fair based on many factors set out in the Matrimonial Property Act, including the roles and contributions of each spouse during the marriage, the income earning capacity, liabilities, and obligations of each spouse, the length of the marriage, any agreements between the spouses, prior court orders, or the dissipation of property by a spouse. For a complete list of factors that a judge will think about, these are listed in Section 8 of the Matrimonial Property Act. Dissipation is the unjustified wasting of matrimonial asset. So for example, if someone did not take care of a home and it fell into disrepair, that might be considered dissipation of that asset. One example of property that may be divided unequally are increases in the value of an exempt property. So for example, Peter inherited a cottage from his parents a few years ago. At the time Peter inherited it, it was worth $100,000. Now it's worth $120,000. That $20,000 increase could be shared between the spouses in whatever way is just and equitable. For example, if the property increase is due to the work that Peter put into the property on his own, then perhaps Peter should receive a bigger share of the value than his spouse. Another type of property that may be divided unequally is property that is purchased using income received from an exempt property. So for example, Louise inherited a house from her parents. She rents the house out and puts the rental income into the investment. Louise may have to share the money that she makes from her investments with her spouse, even though the house itself is exempt. But she could argue that she should receive more than her spouse because she did all the work for the rental property and the investments. Property that was acquired after the separation may also be divided unequally. Syed bought a new home to live in after he separated from his spouse. He purchased the home using money from his parents as a deposit, and his spouse has never lived in the property. He could argue that he should not have to share the value of the property with his spouse, or that his spouse should receive very little of the value, because it was not purchased using matrimonial property or treated as part of marital property. Finally, property that was a gift from one spouse to the other is likely to be divided unequally. As an example, Reese purchased jewelry for her husband throughout their marriage. He could argue that he should receive a bigger share of the value of the jewelry because it was his gift and for his use only. All of the property that is left will generally be divided equally. This includes the matrimonial home, vehicles, investments, etc. The next step is to do the math. Let's go through an example. Joe and Beth are getting divorced after being married for 15 years. Beth owned a condo before the marriage, and it was worth $150,000 when they married. They rented Beth's condo out and bought a house together worth $300,000. Joe had $40,000 in savings when they got married. They just got appraisals done on the properties, and Beth's condo is now worth $200,000, and their home is worth $400,000. How will they divide their property? Property that each of them owned before the marriage will not be divided if the exemption can be traced. Beth still owns the condo, so she will get a $150,000 exemption. Joe will get a $40,000 exemption because he can trace his savings directly into his RRSP. Some property will be divided unequally based on what is fair in the circumstances. Beth's condo was worth $50,000 more now than it was when they got married. This increase in value will be divided, but based on what is fair. Beth did most of the rental property management, and Joe helped with some of the property maintenance. So they agree that they'll do a 60-40 split, and that's fair. Beth will receive 60%, so $30,000, and Joe will receive 40%, $20,000. If Beth had done all the property management and maintained the property alone, then it might have been fair for Beth to keep more of the value. The rest of the property will be divided equally. This includes the matrimonial home. Beth will get $200,000 and Joe will get $200,000. The final step is to decide how the property will be divided between the parties. As long as each party gets the value that they should have at the end of the division, they can decide how they're going to make that happen. So, can one spouse afford to buy the other out of the piece of property? Can some or all the property be sold and then the proceeds of the sale be divided? Can one type of property be transferred to the other spouse? Can you use a tax-free rollover? Property division can be very complicated. There are experts that can help you, including lawyers and accountants. Now let's talk about property division for people who are not married. Unlike property division with married people, where there's a piece of legislation that clearly sets out how property is going to be divided, there isn't such a thing for people who aren't married. In Alberta, unlike many other provinces in Canada, there is no legislation that sets out how it's to be divided. So how property is divided between people who are unmarried is based on what the courts have decided in the past and on common law concepts. Generally, we talk about unjust enrichment. So that talks about where one person received a benefit at the other person's expense. This is how we consider division of property for people who are not married. To consider how property will be divided between unmarried people, there is a chart on page 17 of the handbook that goes along with this presentation that shows how property will be divided between people who are not married. If there is a jointly owned asset, usually a joint asset will be divided equally and the value will be shared between the partners. So regardless of whether or not a couple is married, if they purchase a home together in joint names, it's likely to be divided equally between the partners. If the property that is jointly owned is real estate, then the Law of Property Act applies. If the property is not jointly owned and one partner owns the asset, sometimes it might not be fair to let the partner keep the asset because the other partner has contributed in a non-financial way to the property. For example, Bill is the sole owner of the house that he lives in with Anne. They have lived together for 5 years. Anne helped with the yard maintenance, renovated the inside of the home, and did the majority of the housekeeping. It might not be fair to let Bill keep the entire value of the house given the unpaid work that Anne contributed to the property. As another example, Maria and Jim have lived together for 10 years. Maria owns her own catering business. Jim helps her when she is short-staffed, and he does all of the bookkeeping. He's never been paid for any of these contributions. So it might not be fair for Maria to keep all of the business proceeds. When making a decision about how to divide property, a judge will think about several things. The non-owner partner can make a claim for unjust enrichment. And in this case, the non-owner partner has to prove that the owner gained something, the non-owner suffered a loss, and there was no legal reason for the gain or the loss. If the judge decides that the owner partner has been unjustly enriched, then the judge will place a value for the non-financial contributions of the partner. Let's go through an example. Sam moved into Paul's house, and only Paul is entitled to the home. Paul works at a job outside the home, while Sam takes care of the household and the children. Sam does all of the chores, oversees the home maintenance, and has been involved with renovations to the home. Sam wasn't paid for these contributions, but the contributions mean that Paul is able to dedicate time to his career. After 10 years, they end their relationship. Sam doesn't think that it's fair that Paul should keep all the value of the house simply because his name is on title. The first question is, did the owner gain something? In our example, yes, Paul benefited because he hadn't had to hire a cook, housekeeper, or nanny, and he was able to concentrate on his career while Sam took care of the home and the children. The second question is, did the non-owner partner suffer a loss? Yes, Sam has suffered a loss because there was no financial compensation for all the work that he did in the home. Sam could have worked outside the home as a cook, housekeeper, or nanny and been paid. Finally, is there a legal reason for the gain or loss? There is no legal reason for the benefit or loss. Sam was contributing to their family in a non-financial way because his actions benefited the entire family. If unjust enrichment has been found, then we need to value the unpaid contributions. Here, Sam could research to find out how much the services that were being provided were worth outside the home. The judge might award a monetary amount that is reasonable given the work that was done and the circumstances. Sometimes there's a dispute about who lives in a home while the property is being divided. It's best for partners to try and make an agreement about this with their spouse or partner. They should think about what's in the best interest of the children. But if you cannot reach an agreement, then you can apply for an order for exclusive possession of the matrimonial home and/or the household goods. If the order is granted, then you receive a right to live in the property for a set period of time. You can also apply for an order that says that the household goods must stay in the home. A judge will decide what goods should be included based on what is needed to be able to use and enjoy the family home for transportation, household, educational, recreational, social, or aesthetic purposes. You can apply for exclusive possession even if you are not entitled to the family home or if the family home is a rental property. Both married and unmarried people can enter into an agreement. If you're married, then the Matrimonial Property Act sets out the rules you must follow to make a binding agreement. To make a binding agreement, each spouse must meet with separate lawyers. The spouses have to acknowledge that they are aware of the nature and effect of the agreement, they are willing to give up possible future claims to the other spouse's property, and they are executing the agreement freely and voluntarily and not being pressured into signing. Remember, agreements can be made outside of court, and there's a number of methods to use. See the spectrum of options on page 12 of your handbook, and we've talked about this earlier in the presentation. If you are able to make an agreement, you usually cannot change your mind later on, especially as it relates to matrimonial property. There are only limited circumstances where the agreement might be set aside. For example, if you're forced to sign the agreement, if you received incomplete or false financial disclosure, you should talk to a lawyer before taking any steps to reopen an agreement. There are a number of community resources available in Edmonton and Alberta. Please refer to the Edmonton Community Legal Centre website for more information about these resources, in the handbook that accompanies this presentation, or below.